Good morning, everyone. Am I audible? Please type yes in case if I'm audible to everyone. And also that the slides are visible on your screen. Good morning, everyone. I welcome everyone who has joined just now. Before starting with the session, I would like to know whether I'm audible to everyone and also whether you all can see the slides on your screen. Okay. Everyone, whoever is online, kindly please give a reply with regard to the fact that I'm audible to everyone and the slides are visible on your screen. Okay. So many of you might know me, and many of you do not know me. So to begin with the introduction, my name is Shishir Srivastava, and I'm an advocate who's practicing in the High Court of Chhattisgarh, and I am currently being associated as also as an instructor for the judicial services coaching with Rostrum Legal, and together we run the judicial services exam preparation masterclass at Rostrum Legal. And today I'm going to conduct this open session on adverse possession. So this was all about me. I would like to know who all are you and from where are you, which year are you studying, whether you are a student or a professional working in the courts or law firms or as an in-house counsel. So please, in case if we can have a quick brief intro about ourselves. Yes, Shrishti, can we start with you? Oh, that's very good. You're from HNLU Raipur. Welcome, Srishti. Anybody else? Anybody else? Anybody else who would like to give the quick intro? Meghna. Welcome, Meghna. Okay, I will start with the session for today, and today's topic for discussion is concept of adverse possession. And as we all know, that the concept of adverse possession is associated with the law of property. If I speak jurisprudentially, then the law of property is the starting point of law, or the evolutionary stages of the law. The concept of law or the order in which the person should conduct themselves started with the concept of property. It is said in jurisprudence that property एक starting point था law के evolution के लिए, because everybody wanted, whether it was a movable property or immovable property, everybody wanted to have some control over the property. And since the beginning, the power has always been conferred or considered to be with those persons who have been in the possession of lots of properties, whether it is a movable property or it is an immovable property. The concept of adverse possession means that the possession of the person, and I'll start with, and I'll let me first change the slide for it. The concept of adverse possession means that the possession of the person is adverse to the title of the true owner of the property. I am the owner of the property, but no, I'm not in the possession of the property. Somebody else is in the possession of the property. And now the question is the validity of the possessory title of the person who is currently in possession. Now, he can be my tenant, or he can be a licensee. Licensee, say for example, I have, taken on rent a room of a hotel. So, whatever room of hotel I have taken on rent is the license for the use of that room for 24 or 48 hours. So that is the concept of license. So either it can be a lease, or it can be a license, or it can be something else like mortgage, exchange. It can be any means by which the person other than the true owner of the property can be in possession. Now, if it is through any assignment, lease, exchange, gift, or license, then the possession is said to be a valid possession. But if there is no such authority authorizing the person to be in the possession of the property, then his possession will be considered to be adverse to the title of the true owner, because technically the true owner of the property is supposed to be in the possession unless he has not dispossessed it under any lease agreement or any license agreement or under any exchange or under any mortgage. So if there is no such authorization, if there is no such execution of the agreements which authorizes the person who is not the owner of the property to be in possession, then under those circumstances, if any person other than the true owner is in possession, his possession will be called the possession in adverse to the title of the true owner, and that is what we call adverse possession. The concept of adverse possession is basically determined by the law of limitation, which is given in Article 65 of the Schedule of the Limitation Act 1963. Article 65 prescribes that if some person is in possession of the property adverse to the title of the true owner, then the true owner can institute a suit, or should I say, he shall institute a suit within a period of 12 years from the date of dispossession based on his title. If I am the true owner and I am convinced of the fact that the person who is currently in the possession of my property has not been authorized by me and in any way to be in the possession, and I am also convinced of the fact that due to this particular reason his possession is adverse to the title of my adverse to my title, then I have a period of limitation of 12 years to institute a suit from the date I come to the knowledge of the fact that I have been dispossessed by the person whose possession in my property on my property is adverse to my title. So this is the period of 12 years under Article 65 of the first schedule of the Limitation Act of 1963. Now, where the question will be, which sections or which provisions of the law authorizes us to institute the suit? So we have two sections for it. One is Section 5 and the other is Section 6 of the Specific Relief Act. Section 5 is a two-line section very simply stating that a person entitled to the possession of specific immovable property may recover it in the manner provided by the Code of Civil Procedure 1908. Right? So the fact is, if I am the person who is entitled to the possession of the property, I can recover it in the manner provided by the CPC. Generally, it is understood that the person who has the title over the property and wants to recover the possession of the property based on title can institute a suit under Section 5. But this is a wrong notion. This will be a wrong understanding of Section 5. Because if we give a reading to the Section 5, and as the bare provision is available before you, I cannot find any word like owner in this entire section. So the starting line of the section itself says a person entitled to the possession. It can be anyone. It can be your owner, or it can be a power of attorney holder. It can be anyone. So it is not necessary that the person who is actually the owner based on title can recover the possession under Section 5. It is not necessary. What is necessary is you need to show to the court for the maintenance of suit under Section 5 that you are entitled to the possession, and this is what is the bare minimum requirement for the institution of suit under Section 5. Then the other suit, then the other section under which we can institute a suit is section number 6. So section number 6 I have reproduced below before you as it is given in the Bare Act, that if any person is dispossessed without his consent of immovable property, otherwise then in due course of law. Now I am in possession of property, and somebody comes, posts me out of the possession of the property by putting me on the gunpoint. Now the recovery of the possession by the other person is against the due process of law. That is, he has not approached the court and sought an eviction decree against me. He is forcefully, without the order of law, is dispossessing me out of the property. So I, that is he or any person claiming to him, may by suit recover the possession thereof, notwithstanding any other title which may be set up in suit. So the person who is being dispossessed, merely on the basis of the fact that he was previously in possession, can institute a suit for the recovery of possession based on previous possession against the person who is dispossessing the person currently in possession by putting him in gunpoint, which is against the due process of law, right? But it does not restrains the person to establish any title, institute any suit based on title. अब कोई मुझे जबरदस्ती बिना ड्यू प्रोसेस ऑफ लॉ के किसी प्रॉपर्टी से बेदखल तो कर सकता है, मैं उसके अगेंस्ट सूट भी इंस्टीट्यूट कर सकता हूँ प्रीवियस पोजेशन के बेसिस। बट जिस व्यक्ति ने मुझे अगर बेदखल किया है जबरदस्ती बिना ड्यू प्रोसेस ऑफ लॉ के, उस पर ऐसा कोई प्रतिबंध नहीं रहेगा कि वो उसी सूट में अपना टाइटल स्टैब्लिश ना कर सके. He will be entitled to establish his title in that particular suit. So the non-obstant clause which has been here given, that notwithstanding any other title which may be set up in such suit. Now I am claiming the possession of the property based on previous possession. That is a different fact altogether. But the fact is कि जिस व्यक्ति के अगेंस्ट मैंने ये सूट इंस्टीट्यूट किया हुआ है, उस व्यक्ति पे ऐसा कोई प्रतिबंध नहीं है कि वो अपना टाइटल इस पे सेटअप ना कर सके. तो अगर कहीं से भी वो ये शो कर देता है कि he has a title better than mine, then he will be considered to be a person entitled to the immovable property. Is this point clear to everyone? Is this point clear to everyone? इतना सबके समझ में आया? Before I move forward with section 6. Yes, Meghna, it is lease too. Lease is also a kind of authorization to the other person to acquire the possession or to enjoy the possession of the property. If we see the definition of lease in Transfer of Property Act, then the definition itself says that where the possession of the property is transferred for the purpose of enjoyment. So lease is basically the delegation of the possession to some other person who is not the owner for the purpose of enjoying the property against which some rent is collected by the true owner. इतना सबके समझ में आया जितना सेक्शन 6 तक अभी मैंने आप लोग को बताया है. Okay, now the subsection 2 of section 6 says no suit under this section shall be brought after the expiry of the 6 months from the date of dispossession and against the government. So there are two riders. Clause A is putting a limitation of time that the suit on the basis of previous possession can only be brought within 6 months and not thereafter. And clause B is saying that no such suit can be brought against the government. This is because of the fact that because of the concept of eminent domain. The concept of eminent domain entails the fact that the Government or the state is the owner of all property. So even if we hold even if we hold any immovable property or any property under ownership title, this title has been conferred to us by the government or by the state, which they can take away from us at any point of time. And this is what is the concept of eminent domain. Before 1948, before 1978, before the 44th Constitutional Amendment Act of 1978, right to property was a fundamental right under Article 19 as well as under Article 31. But thereafter, now it has been after 44th Constitutional Amendment Act of 1978, a new Article 300A has been inserted, and right to property has been removed from the chapter of fundamental rights. Now it is no more a fundamental right, but yes, certainly it is a constitutional right. And therefore, since it is not a fundamental right, it is not prohibitory on the government under Article 13 not to frame any law which takes away any of our right to property. So this gives legitimacy to the concept of eminent domain. So we cannot institute any suit against the government if the government has under Land Acquisition Act acquired our property and giving us any amount of compensation against it. So that will be a complete valid legislation, that will be a complete valid execution of the law, and that will be a complete valid executive order, which is acquiring our property. Clause A is putting a limitation of 6 months. Now the question will always arise. Well, it is 6 months here in section 6, and Article 65 of the Limitation Act is giving us the period of 12 years. Then what is the confusion? What in case if there is a conflict? So I will tell it to you later that there is no conflict between two provisions. Section 6 का सूट हम तभी इंस्टीट्यूट कर सकते हैं when we are claiming the possession based on previous possession. We are not claiming the possession based on title, and therefore this is how we come to section 5 and generalized it that the suit under section 5 is generally based on the title, but no such word of title has been used in section 5. So section 6 authorizes us to recover the possession if we have been dispossessed, and we need to show that we were dispossessed from 6 months before. Within 6 months if we have instituted the suit, तो हमको ये शो करने की जरूरत है कि सूट इंस्टीट्यूट करने वाली तारीख से 6 महीने पहले ही मुझे इस प्रॉपर्टी से डिस्पोजेस किया हुआ है. The subsection 3 bars any appeal. So it says no appeal shall lie from any order or decree passed in any suit instituted under this section, nor shall any review of such order be allowed. So there cannot be any appeal against any decree passed under section 6. Also, there cannot be any review for any decision or decree passed under section 6. And subsection 4 is reiterating the non-obstant clause of the first subsection 1 of section 6, that nothing in this section shall bar any person from establishing his title to such property and recover the possession thereof. And in notwithstanding, that is the non-obstant clause of section 6, subsection 1 of section 6, we have seen that even if I institute the suit against the person who has wrongfully dispossessed me from the property, it will not restrain that person to establish his title. So even if between the same parties and on the same subject matter or over the same property, if the person, if the defendant is establishing a counter suit or establishing another suit wherein he is claiming or instituting a suit for declaring him to be the owner of the property, it will not be barred by res judicata. So subsection 4 can also be considered as an exception of res judicata, क्योंकि यहाँ पे डिपेंडेंट को ये कोई बार नहीं है कि वो उन्हीं पार्टीज और उन्हीं सब्जेक्ट मैटर में प्लेंटिफ के अगेंस्ट एक और कोई सूट इंस्टीट्यूट कर सके जिसमें वो अपना उस प्रॉपर्टी पे टाइटल एस्टैब्लिश करने के लिए अधिकृत होगा. तो अगर उसको लगता है कि उसके पास मेरे से टाइटल बेटर है उस प्रॉपर्टी के ऊपर, तो वो एक दूसरा सूट भी मेरे अगेंस्ट इंस्टीट्यूट कर सकता है. पर अगर हम सेक्शन 11 सीपीसी को देखेंगे तो सेक्शन 11 सीपीसी जो है वो रेस जुडिकेटा को बार करता है, तो सेम पार्टीज और सेम सब्जेक्ट मैटर में दूसरा सूट इंस्टीट्यूट नहीं किया जा सकता. तो हम एक तरीके से सबसेक्शन 4 में दिए गए कानून को, जो सेक्शन 6 के उसमें दिया हुआ है, सबसेक्शन 4 और सेक्शन 6 में दिए गए कानून को वी कैन कंसीडर इट टू बी एन एक्सेप्शन of the concept of res judicata as incorporated in section 11 of the Code of Civil Procedure. Is this point clear to everyone? No, it is not it is not ultra vires. It is not ultra vires for the reason that it is for a summary disposal of the cases pertaining to the possession of the property. Any dispute related to the possession of the property should be summarily disposed of, and therefore the review and appeal has been excluded. Anyways, the appeal provision or the review provision or the revision provision is not something which we can claim as a right. It is something which is granted to us by the law. So if the law allows us to file an appeal against this order, if the law permits us to file any review or revision against this order, only then we can claim the right. If the law prohibits it, or if the law does not provides any appeal or any review or any revision against the order, it will be contrary for us to claim it as a right. So merely the fact that generally we are permitted to file appeal, review, or revision does not does not means that where it is also not permitted, we can claim such rights of appeal, review, or revision. So appeal, review, or revision are a matter of statutory rights. So if the statute confers it upon us, we can claim it. If the statute does not confer it upon us, we cannot claim it. Point is clear to everyone? Is it clear to everyone? Guys, this is an open session, and this concept has been explained to you, and the purpose is so that you can interact with directly with me in case in the ongoing class. So अगर आपको लगता है कि कोई चीज़ अगर ऐसी है जो आपको नहीं समझ में आ पा रही है, तो उसको मैं अभी एक्सप्लेन करूंगा. This is what is the purpose of this live interaction. Yeah. Okay, I'm moving forward to section 110 now. Now, the section 110 of the Evidence Act says, now we have to see section 5 and 6 in association with section 110 of the Evidence Act. This is dealing with the burden of proof. It says, when the question is whether any person is owner of anything of which he is shown to be in the possession, the burden of proving that he is not the owner is on the person who affirms that he is not the owner. तो अब मैं अगर possession में हूँ property के, तो I will be considered to be the owner of the property as per the rule contained in section 110. So section 110 का एक ही मंत्र है, possession is the proof of title. So if I am in the possession of the property, I will be considered to be the title holder of the property, even though I do not have any title documents with regard to the property. And therefore, if somebody who is not in possession of the property claims that Shishir Srivastava, who is currently in the possession of this particular plot of land, is not the owner of this particular plot of land, the burden of proof will be upon that particular person to prove the fact that I am not the owner of this particular plot of land. Until then, if he cannot establish his title better than my title in the court of law, then the court will consider me to be the owner based on the possession. And this is what is the mantra. And this rule of evidence is applicable in all these property suits, and wherever the question, title based on possession is under consideration. So section 110 will come into assistance. So as per section 110, you can consider it to be a mantra that possession is the proof of title, unless and until some other person does not establish his title better than the title of the person who is currently in the possession. And the time limit for the other person, if he thinks that the possession of Shishir Srivastava is contrary to the title of the other person who is not in the possession of the property, he will have to, within 12 years as per Article 65 of the Limitation Act, will have to institute a suit against me to establish his title better than my title. This is what is the comprehensive reading of section 5 and 6 of the Specific Relief Act in association with section 110 of the Indian Evidence Act. Now, some bullet points on section 5 and 6. So, nowhere section 5 and 6, as I've told you, claims that the suit under those sections can be filed by the person having the title over the property. If any person who claims that he is entitled to the possession of property can institute a suit under section 5. And for a suit under section 6, what you need to show is that 6 months before the date of dispossession, you were having the possession of the property. What you need to show in a suit based on section 6. Now, for a suit under section 5, the person not in possession must have a title better than the title of the person in possession. As I have told you, 110 claims that the person in possession is presumed to be the owner. Now, the burden of proof is upon the person who is not in the possession of property, but claims that the person currently in possession of the property is not the owner. So, the person who is not in the possession will have to show, the burden of proof will be upon him to show his title better than the title of the person who is currently in possession. And as I have also told you, that such suits can only be instituted within the period of 12 years from the date of dispossession, as per Article 65 of the Schedule of the Limitation Act. Why? Then we also need to read section 27 of the Limitation Act, which says that at the determination of the period thereby limited to any person for instituting a suit for possession of any property, his right to such property shall be extinguished. So, in case of adverse possession, if you know that some person is in possession of your property and his possession is adverse to your title, then you have a period of 12 years to institute a suit for ejectment or for declaration of your title. If you do not do so within 12 years, as per section 27, you will lose all your rights in the property, and that is how the person in adverse possession of the property will acquire the title based on adverse possession. He will perfect the title based on adverse possession over such property. With regard to suits under section 6, it has been very clarified, it has been clarified in the section itself that such suits can only be instituted within 6 months because it is not a suit based on title, it is a suit based on previous possession. Second, the suit is always based on previous possession, as I told you. You cannot institute such suits against the government. And you can institute such suit even against a person who is a title holder of the property, provided he has dispossessed you without due course of law. If some person says that he is the title holder of the property, he should approach the court for acquiring the possession of the property. He should not take the law in his own hand. He should not put me on the gunpoint and ask me to evict from this property. He cannot do so. He should not take the law in his own hands. He will have to approach the court for getting me evicted out. And last, it does not bar the person who claims to be the owner of the property to establish his title over the property either in the same suit or through some another suit. And if we institute some another suit, it will not be treated. It will not be barred by res judicata under section 11 of the Code of Civil Procedure. With regard to the interpretation, it is being stated that as per the application of section 5 and 6 with regard to section 110 of the Indian Evidence Act, there are different opinions of the different high courts expressed through different judgments. Say, for example, the Bombay High Court in Hanumant Rao versus Secretary of State for India in 1900. Just a second. Just a second, guys. Just a second, I will come back to you. Yes, if you can see the ruling of the Bombay High Court and Hanumant Rao versus Secretary of State for India, you will see that under section 110, it has been very appropriately clarified by the Honorable High Court of Bombay with regard to the position of law under section 110 with section 5 and 6 of the Specific Relief Act. And it says that under section 110 of the Indian Evidence Act, possession when long and continued up to recent date leads to presumption of title. So it needs to be a long possession if it has to give rise to your possession, if it has to give rise to your title based on possession. Now, where conflict is between mere previous possession and recent actual possession, the fact of previous possession will not disentitle decree to plaintiff a decree except in suit under section 9, which is the current section 6 of the Specific Relief Act. Now, we had a Specific Relief Act in the year 1877, and the perimetry provision of section 6 was section 9 of the Specific Relief Act of the old 1877 Act. Now, if it is brought within 6 months from the date of dispossession, let's read it once again. Where conflict is between the mere previous possession and recent actual possession. अब किसी को कोई previous possession claim कर रहा है, जैसे कि मैं previous possession claim कर रहा हूँ, तो और मेरे को true owner ने without due course of law dispossess कर दिया और वो actual possession claim कर रहा है, then the fact of previous possession will not disentitle a decree to the plaintiff, which is me in this regard. A decree except in cases of suit under section 9 brought within 6 months from the date of dispossession. जब तक मैं इसको 6 महीने के अंदर नहीं लेके आता सूट को, तब तक मुझे डिक्री डिनाई नहीं की जा सकती, because I am bringing the suit based on previous possession. Now, where this period is exceeded before a suit is brought and is less than the limitation law requires, he must make out a prima facie title. Now, if I do not institute a suit within 6 months, मेरे को तो dispossess कर दिया true owner ने, and if I do not bring the suit within 6 months to recover the possession based on previous possession, then if I bring the suit after 6 months but within the period of 12 years, then I need to show prima facie that I have a title over this property, or my title is better than the person who is currently in possession of the property. Section 110 refers to the presumption to be made of ownership based on the circumstances of such possession, and allows the plaintiff with such prima facie title claim a degree where no superior title is proved by the other side. Now, if the person who has dispossessed me, if he cannot make out his title, if he cannot prima facie proves that he has a title better than me, whom he has dispossessed within 6 months, मैंने 6 महीने के अंदर सूट लेके नहीं आया, मैं 6 महीने के बाद लेकिन 12 साल के अंदर सूट लेके आ रहा हूँ, तो मुझे प्राइमा फेसा ये तो शो करना पड़ेगा कि मेरे पास टाइटल है, तभी तो मुझे कोई इंटरिम रिलीफ भी मिल पाएगी। अगर मान लो मैं एक टेम्परेरी मैंडेटरी इंजंक्शन की भी अगर मैं की डिमांड करूं अंडर सेक्शन 38 ऑफ द स्पेसिफिक रिलीफ एक्ट, तो मुझे प्राइमा फेसा ये तो शो करना पड़ेगा कि आई एम द ओनर ऑफ दिस प्रॉपर्टी, तो ये मुझे शो करना पड़ेगा। एंड इफ द पर्सन हु हैज डिस्पोजेस्ड मी क्लेमिंग हिमसेल्फ टू बी द टाइटल होल्डर ऑफ द प्रॉपर्टी, इफ ही इज नॉट एबल टू प्रूव हिज टाइटल, or if he is not able to prove his title better than my title, then he will not be entitled to the possession of the property, और मेरे को interim relief मिल सकती है। It is in reference to such cases that it has been held that possession is the evidence of title. Now, it is all depends upon the fact that who can prima facie prove his title over the property. जो साबित कर सकता है उसको क्लेम उसको रिलीफ मिल जाएगी, और अगर कोई साबित नहीं कर पाया तो जो भी व्यक्ति पोजेशन में है उसको उसका ओनर माना जाएगा। और इस कानून के पीछे that possession is the proof of ownership, यही लॉजिक चलता है कि जो भी व्यक्ति क्लेम कर रहा है 12 साल के अंदर कि वो इस प्रॉपर्टी का असली मालिक है, असली हकदार है, then he should prima facie show to the court till the disposal of the suit that yes he has a title over the property. Now in case if I am also not able to show, मेरे को तो डिस्पोजेस किया गया है, even if I am not able to show the possession the title over the property, कि भैया जो भी जिस भी व्यक्ति ने मुझे गलत तरीके से डिस्पोजेस किया, मैं 6 महीने के बाद सूट लेके आ रहा हूँ और किसी व्यक्ति ने मुझे गलत तरीके से डिस्पोजेस किया है और मैं ये शो नहीं कर पा रहा कि मेरे पास इसका टाइटल है, आई विल नॉट बी एंटाइटल्ड टू एनी रिलीफ। आई वुड हैव बीन एंटाइटल्ड टू द रिलीफ अगर मैंने सेक्शन 6 के अंदर 6 महीने के फ्रॉम द डेट ऑफ डिस्पोजेशन 6 महीने के अंदर मैंने कोई सूट इंस्टीट्यूट किया होता, देन आई वुड हैव बीन एंटाइटल्ड टू एनी रिलीफ ऑफ पोजेशन। पर क्योंकि मैं 6 महीने के बाद लेकिन 12 साल के अंदर अब अगर टाइटल के बेसिस पे मैं सूट इंस्टीट्यूट कर रहा हूँ तो मुझे प्राइमा फेसा अपना टाइटल शो करना पड़ेगा। और अगर मैं अपना टाइटल उस व्यक्ति के अगेंस्ट शो नहीं कर पाया जिसने मुझे जबरदस्ती विदाउट ड्यू कोर्स ऑफ लॉ प्रॉपर्टी से धकेला था, तब उसके खिलाफ मैं कोई भी पोजेशन क्लेम नहीं कर सकता क्योंकि मैं खुद ही टाइटल प्रूफ करने में फेल रहा हूँ। तो इट ऑल डिपेंड्स अपॉन द टाइटल ऑफ द प्रॉपर्टी। तो जो व्यक्ति टाइटल शो कर सकता है ही विल बी एंटाइटल्ड टू द रिलीफ, जो व्यक्ति टाइटल प्रूव नहीं कर सकता उसके लिए सेक्शन 110 बोलता है कि यस सिंस ही इज इन पोजेशन ऑफ द प्रॉपर्टी the law will presume him to be the owner. So this is the logic behind why under section 110 this law has been made that the possession is the proof of ownership and the burden of shifts on the person who is not in possession of the property. Now the view of the High Court of Calcutta has held in series of cases that previous possession is not sufficient under section 9, which is quite contrary to the opinion expressed by the High Court of Bombay in the case which we have just discussed. Now these are the cases where this opinion of Calcutta High Court has been expressed. In contrary to this, the High Court of Madras finds corroboration from the views of the Bombay High Court that yes previous possession is sufficient proof of title. We always have to remember guys that section 6 के सूट में हमको रिलीफ तभी मिल सकता है जब हम 6 महीने के अंदर सूट लेके आए। 6 महीने के अगर हम सूट लेके आ रहे हैं तो हम 6 महीने के पहले जो हमारा पोजेशन था बेस्ड ऑन अ प्रीवियस पोजेशन हम अपना पोजेशन वापस क्लेम कर सकते हैं, भले ही फिर जो जिस व्यक्ति के अगेंस्ट हमने सूट लाया है वो अपना टाइटल स्टैब्लिश करने के लिए कोई और सूट इंस्टीट्यूट करता रहे। बट द फैक्ट इज कि प्रीवियस पोजेशन के बेसिस पे मैं अगर कोई पोजेशन क्लेम कर सकता हूं तो वो सिर्फ सेक्शन 6 में। अगर सेक्शन 5 के अंदर मुझे सूट लेके आना है, मैं 6 महीने के अंदर सूट नहीं लेके आ रहा, मैं 12 साल के अंदर सूट लेके आ रहा हूँ ताकि मेरा एडवर्स पोजेशन कोई और क्लेम ना कर ले, तब अगर मेरे को उसके अंदर सूट लेके आना है तो मैं सिर्फ और सिर्फ टाइटल के बेसिस पे ही सूट लेके आ सकता हूँ। Is this point clear to everyone? Is this point clear to everyone? Now coming to the fact whether adverse possession is a ground of defense, तो पहले जब 2019 के पहले की अगर पोजीशन ऑफ लॉ की मैं बात करूं then the adverse possession has been only a ground of defense. मैं कभी भी उसके बेसिस पे एक डिक्लेरेशन सूट इंस्टीट्यूट नहीं कर सकता था कि हाँ भैया मेरे 12 साल पूरे हो चुके हैं इस पोजीशन में एडवर्स टू द टाइटल ऑफ द ट्रू ओनर और अब मैं अपना डिक्लेरेशन करवाना चाहता हूँ इस प्रॉपर्टी के ऊपर एज अ ओनर। मैं ऐसा कोई सूट इंस्टीट्यूट नहीं कर सकता। हाँ, अगर 12 साल के बाद ओनर को रियलाइज हुआ कि ये उसकी प्रॉपर्टी और अगर उसने मेरे अगेंस्ट सूट इंस्टीट्यूट किया फॉर क्लेमिंग हिज टाइटल or claiming the possession based on title, तब मैं as a defense use कर सकता था इस ground को कि yes, I have perfected a title over this particular plot of land or over this particular property based on adverse possession. But this position of law has now changed from the after the delivery of the judgment by the Honorable Supreme Court in the case of Ravindra Kaur Grewal versus Manjeet Kaur. The complete citation is 2018 19-8 Supreme Court cases 729. इस case में for the first time, and it can be considered as a landmark ruling by the Honorable Supreme Court on the concept of adverse possession. For the first time, the Supreme Court has permitted the plaintiff to institute a suit in case of any dispute they have permitted to institute a suit of declaration or eviction on the ground of the fact that the plaintiff has perfected the title over the property based on adverse possession. So this position of law has changed after Ravindra Kaur Grewal judgment, and now the concept of adverse possession can not only be used as a defense, but can also be used as a ground for institution of a suit against any other person in dispute to for a declaration of the title based on adverse possession or for eviction of any other person on the ground that I have now perfected the title over the property based on adverse possession. Is this point clear to everyone? So this is all what is for today. Now I would like to, now the session is open for everyone. In case if you have any doubt, you can put it. Any doubt with regard to concept of adverse possession, whatever has been taught, you can put it. Also, you can note down the cases which have been mentioned. These are the landmark cases which have been discussed and are sometimes asked in the examination. And the case of Ravindra Kaur Grewal is a recent judgment of the Supreme Court on the point of adverse possession. So there are high chances that it will be asked in the examination. Yes, guys. Now the session is open for everyone. In case if you want to put any doubt, you can. The judgment is of the date. And is the judgment on the concept of adverse possession, Meghna? See, if it is a 2020 June judgment, then definitely this Ravindra Kaur Grewal judgment would have been followed. And since it has been followed, तब हम क्या कहते हैं रविंद्र कौर ग्रेवाल के जजमेंट को हम लैंडमार्क जजमेंट कंसीडर कर सकते हैं. देखिए लैंडमार्क जजमेंट हम किसी जजमेंट को कब कंसीडर करते हैं? व्हेन इट चेंजेस द कोर्स ऑफ लॉ, व्हेन इट चेंजेस द सेट प्रैक्टिस ऑफ लॉ. तो रविंद्र कौर ग्रेवाल को मैं लैंडमार्क इसलिए क्लेम कर रहा हूं क्योंकि इस जजमेंट से इस पॉइंट ऑफ लॉ पे चेंज आया था कि from on the basis of the concept of adverse possession, now a person can institute a suit as a plaintiff to get his title declared over a property, that he has perfected the title based on adverse possession, which earlier before 2019 was not permitted. It was only permitted for the defendants to claim it as a defense if somebody has instituted a suit against them for the recovery of possession based on title. So if they would have perfected the title based on adverse possession, it could have been taken up as a defense. But this position of law has now changed after 2019 from this particular judgment. Therefore, I consider or claim it to be a landmark judgment. Now, that is something which is pertaining to your concept of eminent domain. This has to do nothing with the concept of adverse possession. So the concept of adverse possession is in a contest or dispute between two private persons where the government is not involved. Yes, and the 1978 was the year when the 44th Constitutional Amendment Act was passed, which has removed the fundamental right of property from the chapter of fundamental right to Article 300A, where now it has merely been reduced to a status of constitutional right. Nobody can claim it as a fundamental right. Also, the position of law has now altered after 1978, that there is no restriction on the state under Article 13 not to frame any law which infringes the right to property of the citizens. So now the citizens cannot claim it as a fundamental right. No law can be challenged on the ground under Article 13 that it is violating my fundamental right of property. Yes. Varun, do you have any doubt which you specifically want to ask? Yes. Any other doubt? Anybody? So it was nice interacting with you all. And for the information of everybody, I would like to inform that our next batch is starting from Monday with the Limitation Act of 1963. We are preparing for the civil judge examinations. This is a lockdown period. I wish safety to everyone. And we endeavor to make the preparation to prepare the students for the examinations which will be conducted right after the lockdown is over. Lockdown in the entire country is over. So we wish to prepare for all those examinations which will be conducted after the lockdown phase. And therefore, if anybody is interested, they can please contact the Rostrum Legal. You can visit the website for getting yourself enrolled for the batch which is about to start from Monday with the Limitation Act of 1963. So it was a very nice interaction with you all. Thank you all for coming and attending this session. And for any query, you can post it on the Rostrum Legal. Thank you all. Wishing you all a very good day.